the press begins right after Chapter 1. And a lot of these changes that we're going to talk about right now, they occurred in July of 2019. They're pretty significant changes. Some of this material is pretty straightforward. It was covered in Chapter 1 of your book, like, do I need to be licensed? In general, in New York State, whenever you're working on behalf of another person and you're being paid, you have to be licensed, okay? That's part of Article 12A, and that's what we talk about on the first page. Interestingly, a lot of people ask the question, well, what's the difference between a salesperson and a broker? Well, in general, a broker can open their own company. A salesperson works and is sponsored by a broker. If you work as an associate broker, then you're really a salesperson in disguise. You really have all the same, you can do all the same things that a salesperson can do. But since the law changes of 2007, 2008, okay, so Bernadette, we are on the first page of the section that's called Hot Off the Press. That follows Chapter 1 in your book. So you've got to go to Chapter 1, and then at the end of Chapter 1, you'll see Hot Off the Press. Okay, got it. Okay, so the changes that were made in 2007 and 8 require that you cannot have an office manager who's not licensed as at least an associate broker or higher. At one time, a salesperson could be an office manager. There was no requirement in the statute that required any kind of different license. So that's something that's been different for a while. So, but overall, a real estate broker, they can open escrow accounts, they can manage an office, they can work on their own. Associate brokers can't work on their own because they're still treated as a salesperson. So you want to make sure that you know that. Okay, page 2 of this section. Real estate salesperson, we talk about what's required to get your license. Obviously, a 75-hour course. It's funny, under certain circumstances, you don't need a high school diploma or a GED. You do for a broker's license, but not for a salesperson license. But you have to obviously complete the course successfully, pass the school exam, get your certificate for that. Remember, that's good for 8 years. The state exam, you've got to pass that as well, and that's good for 2 years. And then when you join a real estate company, there's no more paper application that's really used. You're going to go online through e-access, and you click on the appropriate link. And when you go on that link to join an office, I think it's called Associate with an Office. I'm not sure how they say it, but it's pretty obvious when you log into your e-access account. And then what you do is you do the whole application like what you would have done if you printed it out like we did back in the old days, which the old days were just a few years ago at this point, well, maybe 5 years ago now. And then your application kind of sits in limbo. Like it's just kind of lingers out there. And then when you pick the broker you're going to work with, there's like a code that they use to get your application and add their information that says, yes, New York State, I will be sponsoring Susie, new salesperson. And then that's how you actually become active. You're not considered a licensed real estate agent until you are associated with a broker, which can only happen after you pass the state exam and complete your 75-hour course. The 30-hour remedial course at the bottom half of page 2 of this section, it says valid for 8 years. That's a salesperson course. But the term remedial course is the gap course, because anyone who took the 45-hour course, and this is kind of important, I never hear that they ask a question about it, but you never know. If you took the 45-hour course before 2007, when all the law changes happened that added 30 hours to the course, to the one that you're in right now, if they only did a 45-hour course to get their real estate license, they can never become a broker without taking what we call the gap course. The gap course is the section of the book that we're in now and proceeding to the end. Session N, is where it ends, and then A starts everything all over again. That's what we call the gap or the remedial course. So anyone that wants to become a broker, they need to take the gap course if they took a 45-hour course. You folks will not need to have the gap course because you're in the 75-hour course. So it talks about e-access. You want to set that up at some point. The e-access New York, or you just go to Google and type in, just like you see it here, e-access New York, and set up a profile, and make sure you pick a email address that you will use until you die. Okay, it's really important. You don't want to pick some random thing that you hardly ever use. That is not ideal. Because what happens, you might not know this, but if you're audited by the state, they don't love the Postal Service, Department of State. They will send you an email that says you're being audited. The most common audit people get is an education audit. So if you get audited and you don't check your email much, then you get a real nasty thing, certified mail, requesting that you go to court for an administrative hearing. I kid you not. Like New York, they don't play around. So you definitely want to use an email address that you check pretty regularly. Next page. How do I obtain a waiver from the 75-hour salesperson or 120-hour broker course requirement? So it's not a 120-hour broker course. It's 75 plus 45 is how they come up with the 120. The salesperson, the course that you're in now, is actually considered a prerequisite to the broker course. Okay, you can't take that without showing proof of this. So you're not tested on that. You can just read that on your own. Does the message get sent? Message from Stephanie. Does the message get sent to your e-access account as well? What message do you mean? I'm not sure what message, so let me know what message you mean and I'll look again. The bottom of page 3, we talk about what are the continuing education requirements. So here's what I was referencing earlier this evening. All licensees that submit a renewal prior to July 1st, 2021 are required to successfully complete the 22.5 hours, which you know you need. It has to be 3 hours of instruction for fair housing or discrimination, okay? Agency, so if your first renewal in real estate, you need 2 hours of agency. And then every 2 years thereafter, after your first renewal, you only need 1 hour of agency, okay? So let's see what, so if you're being audited or they just need to get a hold of you, no, they don't usually, the state doesn't try to get, it's kind of like the state is a lot like the IRS. If you get a letter from the IRS, usually you get that sick feeling in your stomach. And that's kind of what you get when you get an email from the state. You don't want correspondence. Like they don't call and they don't send you an email like, hope you're doing well, or, we miss you. Like, no, it's not good news. You're usually either being audited or someone has complained about you. I regret to tell you that if you do something wrong in real estate, like remember I was talking about that person before that left a marketing brochure? That person is very lucky that the realtor took the route of talking to the board of realtors about the ethics violation. Because the way to get somebody that really is painful to them is to make a complaint to the Department of State. That's the way to ruin someone's day or month or year, okay? Department of State, they don't play around, don't want to get on their bad side. And so you're not going to get correspondence from them other than every 2 years, 3 months before your license renews, they will communicate with you to let you know that. So then that usually reminds you to hurry up and start working on it. Otherwise, someone complained about you, and now you've got to deal with an investigator and respond, or they're doing a random education audit. So let me explain a moment. Most people, when they do their continuing ed, with us or any school in New York State. Hopefully you don't ever go anywhere else. You really should stay with us because that's the right thing to do. So New York is what we call an audit state. So just know that when you take your continuing ed course, your 22 and a half hours, and you finish it, keep that certificate for 4 years because they can audit you anytime up to 4 years in the past, okay? So let's look at the new requirements at the bottom of page 3 here. We talked about agency. We know about the fair housing. Any salesperson who successfully completes an approved broker course. Of course, you have to complete that. When you take a qualifying course, like you're in a qualifying course now for real estate, the broker course is a qualifying course. Qualifying course means a course that gets you a license at the end of it. But it doesn't include the fair housing requirement. The broker course does not include the fair housing requirement. Page 4, exemptions. So in real estate, exemptions mean that you don't have to take coursework if you meet certain criteria. All licensees will be required. I'm in the middle of page 4 now. All licensees will be required to successfully complete 22 and a half hours. Education must include at least 2.5 hours on the subject of ethical business practices. At least 1 hour of recent legal matters, and at least 3 hours of instruction of fair housing and discrimination. So the 3 hours we've had for a number of years. The agency we've had for years, okay? So out of the 22 and a half hours, you're gonna need 2.5 hours on ethical business practices and 1 hour of recent legal matters, okay? So we have a course that satisfies all of this. It's called Keeping Out of Trouble, Understanding New York Laws. It's a real popular course, and we're actually a grandfathered school. So that means because New York sat down and did all of our courses, you don't have to worry about passing tests. You still have to spend the time. You can't like just log in and just like it's no big deal. Like we verify that you spend the time that New York requires, and you have to do the entire course. But the good news is you don't have to pass a test. When you go to other schools, they require that in order to advance from page to page to page, you have to answer all the questions 100% correct. And if you don't, you get 5 new questions or 10 new questions. And it's really, really annoying. We actually get people, ask Francine if you want. We actually get people that call up and they say, I already paid. I'm losing my mind. I don't even want to do it with that other school. I want to do it with you because I heard that I can just put the time in and I don't have to pass tests. So that's a benefit, but that's with only that one course, okay? If you pick any other courses, and you can do, sometimes people say, well, if I do it, then I can never do it again. You can take the same course every 2 years for the rest of your natural life, every 2 years. And believe me, we have had people to come every 2 years because, you know, there's enough stress in real estate. They don't want an extra stressor to deal with. So they put their time in, and, you know, they say they always learn something. So good, that's good. You know, we're not the moral police. We're not worried about, you know, as long as we follow the law and you follow the law, that's all we care about. So just so you're aware, you can take a course. You just can't take that course twice in the same time period. But why would you? It makes no sense to do that. Okay, so on page 4, you can see that the 15-year exemption is removed as of July 1st. So I don't know if that would show up on the state exam because it's so new, but now you know about it. And the other exemption is attorneys are always exempt from everything in real estate. All they have to do is pay the $150 broker fee, broker license fee, and they have a broker's license. Okay, at the bottom of page 4, we talk about mortgage brokers. Of course, the New York State Department of Financial Services, again, that's the New York State Department of Financial Services, regulates mortgage brokers. That's addressed on page 5. So everything else here is pretty straightforward. Just give it a cursory review, no big exam items there. Page 6. There's a lot of these questions. You read it through once and you never have to look at it again. But let's look at the rebate thing. Middle of page 6. Can brokers pay rebates to customers and offer other incentives? The payment of cash or offering an incentive to encourage a consumer to do business with a broker is permitted. The real property law prohibits brokers from sharing commissions with unlicensed individuals. It's often misrepresented as prohibiting the payment of cash or offering another business-generating incentive to a consumer. This law prohibits a broker from sharing a commission as compensation for activity that would require a real estate license. So this is something you want to discuss with the office that you associate with. They may have a way that they do this. I know a lot of people, they try to avoid, they don't want it to look like a kickback, okay? Kickback is a return of part of the commission to an unlicensed individual. Kickbacks are illegal. So if you want to bring this to the attention of the broker you associate with, see how they handle it, make sure you follow their procedure. We talk about electronic format at the bottom of page 6. Happy to tell you, you don't need to know 19 New York CRR. You don't need to know all of that. The body of the law is what you need, though. It requires that real estate brokers maintain certain records for 3 years, but you knew that you needed to know 3 years, right? We knew that. But it also provides that such records be maintained electronically. Specifically, Section 175.23 provides in relevant part that each licensed broker shall maintain records for 3 years and or paper electronic records. And it goes further. Accordingly, electronic records are not per se prohibited. It is strongly recommended that businesses which store records electronically comply with the CPLR provisions governing business records and electronic reproductions. So you got to make sure that your electronic records are exactly like they're just as crisp and clear as the physical records. Most people still like to print a version of that. Whatever your office tells you to do, follow that. Okay, but know that it's addressed in the law. Page 7. Ceast and desist, frequently asked questions. When we get to that part of the course again and loop around, everything that we already covered is still consistent. That hasn't changed. Cease and desist, that's when we were talking about the other night in downstate New York, like Westchester County and places there in that area. Cease and desist orders are orders from the Department of State for real estate professionals like yourself to be cannot contact homeowners and cannot contact anyone for business. You have to already have a relationship with them to contact them when you're in a cease and desist zone. If you're in upstate New York, I have never seen one in all the years that I've been involved with real estate, and I don't foresee one anytime soon. So it can always change, and your company will notify you. Believe me, it'll be a big deal if a cease and desist order is placed, because it's something that's placed in a neighborhood, a municipality. It's not something that is like a random, like this person and that person. It's not like a do not call registry. It's like a whole community cannot be contacted. Okay. Then we define solicitation on page 8. Read through that. There's a question. They're not going to test you on this, but I just thought it was good for you to know. Does it also include sending out? I'm on page 8 right now. Does it include sending out EDDM, every door direct mail? That's the acronym for, they never called it that before, but that's what they call it now. Marketing postcards to highlight just listed. Yes, EDDMs are considered solicitation. Okay, so that's something you should know. Homeowner refers to owners of single family as well as multifamily homes. Page 9, please know that cease and desist orders only apply for residential real estate, not commercial real estate. In some parts of New York State, realtors are very aggressive. A lot of brokers have fantasies of their realtors being, their associated salespeople and brokers being aggressive to try to get business. But it's really crazy what some of the things are you see in other parts of the state. Page 10, a lot of information about this. I really don't see you getting tons of questions about cease and desist order other than what it is and what it means, okay? Read through this, it'll be helpful for you. And then we want to share with you something that's really, really incredible. Like I never thought in my lifetime I would see something like this. Do you have a criminal conviction? And have you remained crime-free for the last 10 years? The numbers are astonishing. How many people have a criminal conviction nationwide. Like I'm talking about misdemeanors and felonies. So many people that you probably know people, but don't know that they have a criminal background because who's going to be bragging about it, you know? But, you know, a lot of people have had DWIs over the years. And, you know, if you're under 50, maybe 60, under 50, 60 years of age, you should get rid of that. You should get that record sealed following the law. That's, you turn to page 11, who's eligible to seal their conviction under criminal procedure law. Like, make it go away. Follow what you got to do to make it go away, because I'll tell you, it's not we get so many calls from students that they did these crazy things when they were in the military and then they got a record for it, or they were involved in a domestic situation with their spouse or boyfriend, girlfriend, whatever. And then it haunts you for years and years. And if you're really on the, you know, you're being good, you're a good citizen and you're paying your taxes and you're working hard and you're staying out of trouble, take advantage of this. Don't think it's not a big deal. And I also look at it as, hey, you never know if they're going to get rid of this law. So if you have the opportunity to make something bad go away and you earned it and you follow the law, get rid of it. We have some questions that have popped up. Okay. Let me see here. Stephanie says, I get a postcard every couple of months to sell my home. Yep. Now, you can get that postcard because you're not in a cease and desist zone. If you are, that would be a violation of that. Terrorism Risk Insurance Program. That's at the top of page 12. Give that a cursory review. I don't think you're going to be tested on it. I never hear about that. Lots of tax changes. So there's a ton of tax changes that have occurred over the years. Well, in particular, since Donald Trump was elected president, a lot of changes occurred as a result of all that. So 3 important provisions. Again, always go to irs.gov for the details. Number 1, the exclusion of forgiven mortgage debt from gross income, meaning that the owners of primary residences who sold them short and part of their mortgage debt was written off will not have to pay tax on the amount forgiven. Now keep in mind, these things can always change. They rarely, as a matter of fact, the state hates to ask some of these questions because then they have to remember to change everything when the law changes again. Because this is something that kind of has come and gone over the years. So if you have a short sale is where a real estate agent has a house where the people can't make their payments anymore. So instead of just letting them get foreclosed on, they find a buyer who says, look, I know that they owe $150,000 on the house, but I have a buyer who will pay $120,000, and it's better than going through the whole foreclosure process. That's a short sale, when you convince a bank to let a buyer buy it for less than what's owed on the house. We call that a short sale. Okay? So that if they buy it for $120,000 and they owed $150,000, the seller of that property would have a $30,000 difference. That's the amount being forgiven that we're talking about here. So having to pay tax on $30,000 is not fun times. Okay, so you want to make sure that when that happened, if this has happened to you or someone you're dealing with, was it forgiven? Was it during the time frame that the government said, okay, this is a time frame? You shouldn't have to worry about all the details. Like, you should have a conceptual understanding and be able to explain it like I am to you, but have them talk to their accountant. You already wear enough hats as a real estate professional. You shouldn't have to know every minutia of every law, but know that there's a law that covers this, that, or the other thing. We have a question here. No, we don't. Okay. Yeah. Okay. So, so read through the tax extenders here, and then look at page 13 next. So let's look at the mortgage interest changes that occurred January 1st. Now we're covering this because the state can ask you questions about this. They have in the past. It reduces the limit on deductible mortgage debt to $750,000 for new loans taken out And that would be new loans taken out after 12/14/17. You won't be tested on that date, but the concept you will be tested on or could be tested on. Current loans of up to $1 million are grandfathered. So if you already have it before 12/14/17, then you can continue deducting that mortgage debt of up to $1 million. Now, that's not the typical price in Western New York, but in other parts of the country, this is a real big deal. So there's a $750,000 cap that you could be tested on. And if you're in New York City, it's a big deal compared to upstate New York, where our values are half of that or less. Next bullet point on page 13. Homeowners may refinance mortgage debts existing on 12/14/17 up to $1 million and still deduct the interest, so long as the new loan does not exceed the amount of the mortgage being refinanced. There is no longer a deduction. This is huge. Now, this next part is huge. There's no longer a deduction for interest paid on home equity debt through 12/31/2025. So on home equity debt through 12/31/2025, interest is still deductible on home equity loans or second mortgages if the proceeds are used to substantially improve the residence. In other words, banks used to really push, and I don't know if you've noticed all of a sudden, but the banks don't seem to run the commercials for home equity loans like they used to. Because you get a home equity loan, it used to be up to $100,000. You could get a home equity loan and pay off your student loans. You could pay off a car. You could pay off your trip to Tahiti. Like, you name it, you could deduct it. Well, that's all gone. Home equity loans have to be used for the house now. Mortgage debt has to be used for the house. Interest remains deductible on second homes, but follows the $1,750,000 rule that we noted above. Top of page 14. Federal tax law changes effective 2018 and beyond doubles a standard deduction. I never hear about the state testing on this, but just give it a cursory read through just in case you don't get lucky and you get a tough exam. So the standard deduction was doubled. So it's from $6,350 up to $12,000 for single filers, $12,700 to $24,000 for joint filers. The proposals pay for the higher standard deduction in part by eliminating personal exemptions. Because I don't know if you ever did, I'll tell you, one of the best classes that I ever took, and you might want to think about this, you don't get continuing ed for it too often because it's not real estate related enough, but take a class, forget who, H&R Block, that's who I took it to. H&R Block is a class I took, and they still offer classes. It was one of the best classes I ever took. Not that I wanted to prepare taxes to make money on the side, but it helps you appreciate tax deductions that I don't believe I would have got all these years, and things that I don't want to take as a deduction because I don't want to trigger an audit. An IRS audit is not fun. Like, I had a home office for years and years. If anyone had the right to qualify for it, I did. And I never did because, Esther Goulias, I don't know if you're familiar with her. She's come in and she's presented in the classroom over the years for us. And I'll tell you, she's like, Mike, you're crazy if you're not taking these deductions. Like, you have the right, you have the receipts, and I'm like, no, it's okay. I don't have the time. I don't have the time to deal with an audit, even if I have all the paperwork and I'm entitled to it. There's some things I will not take a deduction for if it'll trigger an audit because I don't have the time to deal with that. Tax consequences of the 2017 tax changes. So that they call it the Tax Cuts and Jobs Act. That's what it's called. Now, the state exam does reference the name of the law that they're talking about. So they will call it the Tax Cuts and Jobs Act. It talks about new tax rate reductions. So the 7 brackets we have still are in place. So it goes as low as 10 and up to 37. And the final bill retains the prior law maximum rates on net. Talks about recapture. We're going to talk about recapture more when we do the, we'll talk about recapture more when we cover commercial concepts and coming up very soon, okay? Page 15, we show you under the prior law, the ranges of income and the applicable tax rate. That you will not be tested on. But look at it. It's interesting. Look at it, tax brackets for ordinary income prior to the Tax Cut and Job Act laws. So we could give it a cursory review. We talk about the deductions on page 16 for state and local taxes. This is kind of a big deal, and I see you being tested on this. The $10,000 limit is huge, especially if you're in downstate New York, where people pay $50,000 a year in taxes all day long on their property. Okay, it's make sure you read through that. Imagine a house in the Hamptons. I couldn't even imagine like the tax bill. It'd be ridiculous. Standard deduction we talk about. So kind of read through this. Know what MCC stands for. Mortgage Credit Certificates. So the final bill retains the prior law. So there's been no change. But a lot of times people don't know what an MCC is. It's a Mortgage Credit Certificate. We define that at the bottom of page 16. Mortgage Credit Certificates is a document provided by the originating mortgage lender to the borrower that directly converts a portion of the mortgage interest paid by the borrower into a non-refundable tax credit. Now, you're not going to deal with much of this in real estate. But again, you may talk to people that have utilized them in the past, and you'll have a better understanding of what it means as a result of reviewing this. Page 17. We talk about deductions for medical expenses. I guarantee you, give it a cursory review. You're not going to see much on that. Moving expenses defined, again, really very few. But you will see on page 18, like-kind exchanges. So when you hear, now here's a good trigger word. I know you're probably sitting back saying, oh, I can't wait till this class is over. Me too. But I want to tell you that when you hear section 1031, you should think of, so one side of your flashcard, you put section 1031. On the other side, you put like-kind exchange. That's your trigger word. Like-kind, like, L-I-K-E, like-kind exchange for section 1031. Either way, you hear one, you think of the other. You think of the other, you hear the, okay, either way. All right. Read through the rest of page 18 on your own. It's not too bad. I do want to make sure that you know, super important, before we turn the page. Make sure, please know, in the middle of the page, 27 and a half years is a depreciation schedule for residential property. Now, tonight we don't talk all about how to calculate it and things like that, but please know that for test purposes. 39 years for commercial, or another way of saying commercial is non-residential property. Please know that. We'll talk about on another day when we get into the commercial part how to use this. It's very detailed what we're going to talk about. You might want to take some Tylenol with you that day or have it ready, because most people don't enjoy that class. I don't know. I like it, but I'm a finance guy. So, all right. So know those two items, and we'll talk about in the future why you need to know that. Page 19. Nothing super important here. Just give it a cursory review. Page 20. More income stuff. Yeah. So you're not tested on any of this. This is just extra information that we wanted to make sure you're aware of, because you're in the business, but these are not on the curriculum from New York State. We just like to have when you have a real estate textbook, you want it to be well-rounded. We don't want to we don't teach to the exam. We want to make sure you can make sense of these things. Section 179 expensing, that's sort of a thing that you do when you're in business to expense. Instead of taking deductions each year, when you expense it, you get to take, instead of like some things, you can only take so much each year that you have the property. Well, when you get to expense it, you get to take all those future years all at once. So it gives you a big tax savings in that immediate year. So section 179 refers to taking the big exemption, the big cut in the year, and you save money immediately instead of spreading it out into the future. Page 22, the Housing Stability and Tenant Protection Act of 2019. Oh, the name sounds so innocent, and it's just so terrible. Like, this is so terrible. You don't even know how many people are sad about this. So here we go. We're going to talk about this, and then we're done for the evening. So the Housing Stability and Tenant Protection Act of 2019. So the governor signed this into law on June 14th of 2019. And there's a lot to know. We break down the law clause by clause at the bottom half of page 22. So the new law for non-retaliation, okay? So retaliation is like when you want to get rid of a tenant because of a problem, like maybe they're loud, maybe they do drugs, maybe they're not being good neighbors. Sometimes people do it for wrong reasons too. So retaliations usually, like maybe you have a landlord that's not being, maybe you have a ridiculous landlord. Landlords can be just as crazy as tenants. It's like, it's not one way or the other. It goes both ways. So in an action or proceeding, again, we're going to look at the new law now. In an action or proceeding instituted against a tenant of premises or a unit, which this section is applicable, a rebuttable presumption that the landlord is acting in retaliation shall be created if the tenant establishes that the landlord served notice to quit or instituted an action or proceeding to recover possession, to be possession of the property, or attempted to substantially alter the terms of the tenancy within 1 year after a good faith complaint was made by or on behalf of the tenant to the landlord's agent or governmental unit of the landlord's violation of any health or safety regulation code ordinance, the warrant of habitability under section blah, blah, blah of the law. Okay, so you want to make sure if you have a tenant that's not happy with you, hope that your property meets all building requirements, building code requirements, and is safe. The warrant of habitability is something that's implied with all property. It's assumed that the warrant of habitability will be in place at a property, especially when you rent it out. When you rent out a property, if you live in a two-family home and you don't have a handrail in place, or you don't have lights in appropriate places to illuminate the walkways or the stairways, and there's any safety issues, if you have any of these conditions at any property that you own and you rent out for income, and the tenant, you get into it with your tenant about anything, and let's say they took this course and they're hearing what I'm about to say now. Sometimes we use information in a bad way against people too, unfortunately. And sometimes people just spend a lot of time Googling everything, okay? Especially troublemaker kind of people. So, and I've had some tenants like this over the years. I've had some people that I'm like, wow, why do I have rental real estate? It's like a nightmare. But I've had so few relative to the good people that I've had, but it's going to happen to you at some point. If you own enough real estate, you're going to get some really bad apples from time to time. I don't care how well you've screened them. Doesn't matter how well you've screened them. You're going to get a bad apple from time to time. And you just want to minimize the bad apples to a minimum, okay? So if you get into it with your tenant and you're kind of like done with it, you're tired of them being this way, and you want to get rid of them. If they know the law, and let's say they really like their place because it's close to work, you're charging a fair rate. Those are the big reasons I've had people do similar things to me over the years. They can say that you violated that the warrant of habitability is in place at their property is you're not keeping up with it. In other words, the missing handrail, the lack of lighting, the maybe broken step on the porch. I mean, it really can be minimal stuff, and it could be peeling paint on a home that was built prior to 1978. We call that target housing. You should know that for test purposes. Target housing on one side of your flash card. On the other side of your flash card, you put 1978 lead-based paint. Done. That was the year that we outlawed lead-based paint. So if they really want to if the tenant wants to really put the screws to you and they understand the law, they can go to the building department of your municipality and say that all these violations are there, and I don't feel safe, okay? And then the building inspector comes out, and let's say you're the owner, the landlord, you don't really know the laws because you never took this real estate course, okay? You get really mad. You're like, wow, what a See, I can't use bad words because it's a public forum, but pretend I was using a bad word, okay? This SOB called the building inspector on me? Oh, I want you out. Oh, okay. I just gave you the best definition of retaliation, okay? So the law is, this was never in place before. So the law says that they retaliated because they called the building inspector because they didn't feel safe. So if I read this right, the 1 year rule, like you can't retaliate and that's like very easy to prove that, like, at the timing of everything, even if the concepts are mutually exclusive, I got a news flash for you. It's going to go in favor of the tenant. The landlord in New York is always the bad guy. Always a bad guy. You're always going to lose unless you have a mountain of evidence to the contrary. It gets, welcome to New York. Go to Texas, it's a whole different, like, it's the Wild West, but not in New York. So what does this mean? If in the past, if a tenant lodged a maintenance or habitability complaint with a governmental unit and the landlord non-renewed or evicted a tenant in the following 6 months, it was presumed that the landlord was retaliating and the tenant could recover. Under the new law, this has been extended to complaints lodged not only to governmental agencies, but with landlords or property managers themselves, and the timing. In other words, so suppose I didn't even know that this was 6 months before, but now it's 12 months. Okay, so you want to make sure you know this. You want to make sure that you know that it's 12 months. It used to be 6. You're not going to test on what it used to be, but you need to know that it's 12 months. The retaliation time frame has been extended. So they basically get a full year after they've contacted a municipal office about you. Page 23, we're going to look at number 2, notice of non-renewal or rent increase. Here's the new law. Whenever a landlord intends to offer to renew the tenancy of an occupant in a residential dwelling unit with rental increases equal to or greater than 5% above the current rent, or the landlord does not intend to renew the tenancy, the landlord shall provide written notice as required per subdivision 2 of this section. If the landlord fails to provide, here's the key thing you need to know. If the landlord fails to provide timely notice, the occupant's lawful tenancy shall continue under the existing terms of the tenancy from the date on which the landlord gave the actual written notice until the notice period has expired, notwithstanding any provision of this lease or any tenancy agreement to the contrary. If the tenant has occupied the unit for now, much more detail than we've ever had before, okay? I don't see you being tested on this, but I mean, the other thing, the previous page where we talked about the 12 months instead of 6 months, that I could see it happening. This is too much minutia for but this is definitely something you want to know. Definitely, if you own property in New York State and you rent it out, you want to know this if it's residential property. So if the tenant has occupied the unit for more than 1 year, but less than 2 years, or has a lease term for at least 1 year, but less than 2 years, the landlord shall provide at least 60 days notice. 30 days was always a standard. C, if the tenant has occupied the unit for more than 2 years, now here's where it really gets crazy. If the tenant has occupied the unit for more than 2 years or has a lease term for at least 2 years, the landlord shall provide at least 90 days notice. 90 days. Unheard of. This is a huge change from what we had before. So we explained to you at the bottom half of the page what does it essentially mean, and we just covered that. All right, page 24. Landlord duty to mitigate damages. Here's the new law. In any lease or rental agreement, if a tenant vacates a premises in violation of the terms of the lease, the landlord shall, in good faith and according to the landlord's resources and abilities, take reasonable and customary actions to rent the premises at a fair market value or at a rate agreed to during the term of the tenancy. So what does this mean? If a tenant breaks a lease, a landlord is only allowed to recover lost rent during the vacant period if the unit was re-rented at a fair market rent or the past tenant's rent amount, whichever is lower. Wow. If the landlord chooses to increase rents at this time, the landlord forfeits any right to recover lost rents during the vacancy period. It's huge. Number 4, no screening for evictions. Here's the new law. No landlord of a residential premise shall refuse to rent or offer a lease to a potential tenant on the premises that the potential tenant was involved in a past or pending landlord-tenant action or summary proceeding under Article 7 of the Real Property Actions and Proceedings Law. There shall be a rebuttable presumption. This is interesting. There shall be a rebuttable presumption that a person is in violation of this section if it is established that the person requested information from a tenant screening bureau relating to a potential tenant or otherwise inspected court records. This is the part that I have always done, and most landlords have done this. Or otherwise inspected court records relating to a potential tenant, and the person subsequently refuses to rent or offer a lease to the potential tenant. It's mind-blowing. So what does it mean? It's now illegal for a landlord to screen for prior evictions. I wouldn't believe it if I didn't read it. Well, I wrote it, but when I first read the law, I was like, my God. So if a landlord denies an applicant for any reason and is found that they screened for and found evidence of prior eviction, it will be presumed that the landlord denied the applicant on the basis and have violated New York State law. Evictions will now be sealed. Listen to this. Evictions will now be sealed and not made public. This became effective July 14th, 2019. Welcome to New York. Number 5. Deb, if I could flip upside down my head right now, I feel just like with your emoji there. Number 5, no recovery of attorney fees in default judgment. Here's the new law. A landlord may not recover attorney fees upon a default judgment. What does this mean? If the tenant fails to appear in court for eviction and a default judgment is made in the landlord's favor, the landlord may not attempt to recover any attorney fees. Not that you'd get them anyways, but at least you never know. If you have enough properties, you may get some. Number 6, page 25, number 6. Receipts must be provided for rent. Here's the new law. Upon the receipt of the payment for rent for residential premises in the form of cash or any instrument other than personal check of the lessee, it shall be the duty of the lessor is the property manager or the owner, or any agent for that person authorized to receive rent, must provide the lessee with a written receipt containing the following. Very, very specific here. The date, the amount, the identity of the premises, so that would be like the address, and period for which that was being covered. In other words, a period of time that rent covered. Number 4, the signature and the title of the person receiving the rent. A lessee may request in writing that the lessor provide a receipt for rent paid by personal check. You know that if your receipt doesn't meet in accordance with the law, that will be in the tenant's favor. Like, you got to dot every I and cross every T. My friend cannot get over this. She's a property manager. Oh, I'm glad that you're here. I can't get over it either. Like, wow is the only word I can think of. Like, it's mind-blowing. Number 7. I'm happy to tell you the misery ends really soon. And it's funny. Did you see the movie Misery when, what's her name? She was on American Horror Story, and she just banged the guy in the bed. Was it Robert Kane? I don't remember his name. Robert somebody. And that's what I feel like. Like, that's what New York is the woman, Bates, Kathy Bates, right? Kathy Bates. No one's helping me. There's 13 of you. I hope you're not sleeping. Kathy Bates is banging the crap out of the guy in the bed. Remember, he's tied up, right? He's tied up. He's tied to the bed. This is New York is banging every property owner in New York. It's mind-blowing. Wow. So number 7, late rent notices. Break his legs, yes. So number 7, we're going to look at late rent notices to be sent via certified mail. Here's a new law. If a lessor or an agent of a lessor authorized to receive the rent fails to receive payment for rent within 5 days of the date specified in a lease agreement, such lessor or agent shall send the lessee by certified mail a written notice stating failure to receive such rent payment. Like, that's the law. No other. The best thing that can happen to a landlord is that they get tenants that don't know the law. Because if you get someone that knows the law, oh my gosh, it's not going to be pretty for the landlord that's very loosey-goosey. You know, I remember once I spoke in front of Hartstone Manor, which is now called, I think it's called Grapevine now. Let me know if it's called Grapevine. It's like in Cheektowaga, Depew area there. And what happens is they have monthly meetings. Sometimes they're like every 2 months they'll have a meeting of property managers from all over Western New York. I don't know if they still do it. They used to do it. And I went there and I spoke about all the laws and regulations that apply to property managers. It is called Grapevine. Okay, great. And wow, if you could just see the looks on their faces when I stood in front, there was like 300 people there, and they get together and they talk about whatever they talk about. And they did not, I don't know if they knew what they were in store for when they had me come talk, but everyone's head just went down, and you could just see, like, when I started explaining all the rules and regulations to them, they were like, oh, wow, we don't want to know. Like, not knowing the law doesn't get you out of having to follow the law, So I was actually never invited back again. But we got some comments here. Who owns a property, the landlord or the tenant? Yes, I know. I think New York might own it. The tenant might own it. What if an apartment landlord does not have you sign a lease? All the rules still apply. An oral agreement, a month-to-month tenancy, same thing. Like, actually, a smart and we'll talk about this when we do property management, but a property manager or a property owner should have you sign a written lease that's month to month, even if you're month to month. And it still states all the things that apply as a month to month tenancy. But a lot of people are doing leases these days because you don't have any more, you actually have less rights because all the different assumptions take place when you don't have it in writing. The other thing you should know also is that if you, how do I put this? If the tenant agrees to something, if you both agree to something, and it turns out that there's a law that specifically covers what you both agreed to, and if that law is contrary to what you both agreed to, the law takes precedence, even if you both agreed to it. Just another thing. That's why when people get, so here's a whiff a moment. What's in it for me? Why do I care? When you go to the stationery store or you go online and you Google, leases in New York, or blank leases or free leases, whatever you Google to get a lease, really should have it reviewed by an attorney, because you run the risk of there being things in there that's maybe works in another state but doesn't work in New York. And you're not going to be suing the online people if there's a problem. You're going to go to small claims court and you're going to lose and wish that you spent the $200-300 on a lawyer to review it, okay? I highly encourage you to do that. If you have rental property, don't wait until the nightmare tenant appears. Get this done. Maybe look for a coupon in the home finder from a lawyer that's looking for some more business, or a new lawyer or whatever. But get your leases reviewed. Don't just keep using what you've used, because until you go to court and you have the nightmare tenant mess with you, you don't want to find out that way. You don't want to find out that way. And the other thing that's interesting too, I don't know how much free time you have, but at some point, sometimes it's fun. I say fun in a not fun way. Go to small claims court when they have the tenant eviction nights. And some of the things you'll hear are mind-blowing. The excuses you'll hear, like it's almost like Judge Judy in real life. If you can hear, you want to sit close to the front. They don't always talk really loud. But the thing you want to do is, what's interesting is how the judges are wrong on some of the minutia of the law, and nobody can call them out on it. So when you're like evicting someone or you're doing some kind of a court action, make sure you have the printed law. Here's a big whiffle for you. Have the printed law with you so that when the judge makes the mistake, you can pull it out and say, well, here's the law, Judge, and that will save your you-know-what. I regret to tell you, but the judges make mistakes, especially these town justices that are not like they're like elected or whatever, placed or appointed. Yes, do that. Do that. Really, really important. You should always do that anyways. Mediocrity is everywhere. So don't assume that just because that person's a judge, they know what they're doing, because sometimes they make mistakes too. Okay? A little bit more and then we're done. Page 26, and we're going to look at number 9, limitation on late fees. No landlord, lessor, sublessor, or grantor may demand any payment, fee, or charge for the late payment of rent unless the payment of rent has not been made within 5 days of the date it was due, and such payment, fee, or charge does not exceed $50 or 5% of the monthly rent. Are you sitting down? The next sentence, whichever is less. Whichever is less. Next paragraph. Imposing a late fee limit prevents unscrupulous landlords from charging usurious. Remember, usury is charging a rate in excess of that allowed by law. That's another flashcard you should make up. I'm just trying to divert to something more pleasant, like a term you should know. So on one side of the flashcard, usury, U-S-U-R-Y. That's U-S-U-R-Y. On the other side of the flashcard, charging rates in excess of that allowed by law. That's usury. So usurious is a derivative of that, of charging usurious late fees, but to impose an absolute maximum limit of $50 without regard to how long the rent has been late, or the past payment amount is arbitrary and disproportionately benefits those renting the most expensive properties, without providing much benefit to those in lower income properties. Not to mention, once a tenant has maxed out their late fee, here's the part that kills me. Once they max out their late fee, there's little reason or urgency for the tenant to pay the rent. So pay late and pay 2 days before the next rent payment's due. Wow, that's great. Number 10, only base rent may be sought in an eviction proceeding. Again, only base rent may be sought in an eviction proceeding. So in a proceeding relating to a residential dwelling or housing accommodation, the term rent shall mean the monthly or weekly amount charged in consideration of the use of the occupancy. No fees, charges, or penalties other than the rent may be sought in a summary proceeding pursuant to this article. So what does this mean? A landlord can no longer seek to recoup any fees or charges that a tenant is due in an eviction proceeding. The landlord may only seek to recover the base rent. Like late fees, exist as an incentive for tenants to pay on time. And if a landlord does not have any firepower to collect on those fees, their only option for penalizing a tenant for refusing to pay those fees will be to non-renew their lease, and to take the fees from their deposit or take them to small claims court, driving up vacancy costs and further exacerbating the affordable housing problem that exists in many parts of the state. It's when I heard of all the changes in these laws, all I thought to myself is, wow, I'm happy I sold a lot of my rental property. But it's really sad. Like, I really hope that they change some of these, because there's bad apples out there that can really make life miserable for you. And it's sad. And then it's going to affect property values. Like, you're not going to get as much for rental properties if you get in one of those areas where it's a nightmare to deal with people, you know. I have had rental properties, and I'm not trying to be discriminatory at all. There was a property that I had in the town of Tonawanda that was always a nightmare tenant. And then when that tenant left, maybe the house was cursed. Maybe it was cursed. It was funny that out of all the properties I've owned, that house always had a nightmare tenant. And I couldn't make up the stories. Like, if I tried, it was just mind-boggling to me, the things that would happen there. Yes, Deb, you're right. They work the system. And it was just, believe me, I couldn't sell that house fast enough when I got to the right place in life to get rid of it. It was awful. Somebody cursed it. I swear someone cursed that house. Anyways, a little bit more. We got to let you go. It's getting late. So page 26. We're going to look at page 26, and we're going to talk about number 11 now. Pay or quit notice, time extended. Here's the new law. A special proceeding may be maintained under this article upon the following grounds. The tenant has defaulted in the payment of rent pursuant to the agreement under which premises are held, and a written demand for the payment has been made with at least 14 days notice required. In the alternative, the payment of the rent or the possession of the premises has been served upon them. So hopefully something's jumping out at you about this one. So what it means, in the past, the first step of the eviction process was to formally deliver a notice. They called it pay or quit. So to deliver a notice to a tenant that was late in the form of a 3-day notice. So it was always, what we always had in real estate in New York was 3-day pay or quit. Now it's 14 days. Notifying the tenant in writing that they had 3 days to either pay or vacate. This notice has now been increased to 14 days, 2 weeks, 2 weeks. It's horrible. I can only imagine the damage being done to the property. Because, you know, tenants get mad when you want to collect the rent and they don't feel like they need to pay it. You know, we used to have an instructor, he passed away, but he was a property manager in West Seneca. And he told a story, it was kind of sad. A tenant got mad. It was like, I don't know, it was like 150 units there. And the tenant got mad because they didn't want to pay the rent for whatever reason. I don't remember the reason now. It wasn't a good reason. It was not really a good reason at all. That was a professionally managed building. Our instructor actually managed the building. And so they took a fire extinguisher and they walked down the hallway of the common area, and they started bashing it against the walls of the hallway of the apartment complex, causing significant damage. And then they went to the building inspector and said, "Oh my God, like, this place is terrible. Come and look at it." So when the building inspector came out, it violated the warrant of habitability. And the person did this in order to buy them more time to, like, go through the court process. And that's before it was as liberal as it is now. Like, could you imagine if that tenant was around and this was happening when this was a rule? Wow, it's just horrible situation. So it's sad, because real estate is such a great way, like, for you, when you, a lot of people in the 75-hour licensing course, they start to buy real estate because this is like, you know, you don't have like a pension program, you don't get like a retirement out of real estate, you can't bank on Social Security. So if you can buy a house every couple years, you're in the business, like a 2-family, 3-family home. After you're in the business a number of years, you get those mortgages paid off, and then you have free cash flow, and that's like income for you. So this way, you know, when you start getting older, you don't want to work really hard in real estate. You're just taking care of your properties and collecting rent. This really takes the fun out of doing that, and it makes you not want to have as many properties, maybe, you know. So, but it is, and you know, you got to really think about the people you vote into office. And I'll tell you, if I was in real estate, because I can't have an active license, I would look up the people who pass this law and not vote them back in. That's how awful this is. That's the only way to handle a situation like this. You know, we can't vote these people in that are so closed-minded and just assume that the landlords are just all so awful and horrible. A little bit more on here though, page 26. So rent paid in full during the eviction nullifies the eviction. In an action premised on a tenant defaulting in the payment of their rent, payment to the landlord of the full amount of the rent due when such payment is made at any time prior to the hearing on the petition shall be accepted by the landlord and renders moot, that means nullifies, the grounds on which the special proceeding was commenced. So in the past, if a tenant failed to pay rent after their grace period and a 3-day notice was given, now it's 2 weeks, the eviction process was underway, the landlord was not obligated to accept the rent and could continue with the eviction, probably because it's not the first time the person didn't pay their rent. That's my experience. People are habitual with these things. And then you get to a certain point to where it's like, I can't take it anymore. So under the new law, regardless of the time and expense incurred by the landlord throughout the eviction process and the length of time that the eviction has been drawn out, if a tenant provides payment in full of the rent proceeds at any time during the eviction process, the eviction is thrown out and the landlord's expenses throughout the eviction are irrecoverable. Page 27, tenant response time to petition is extended. Number 13. Here's the new law. The notice of petition shall be returnable before the clerk and shall be made returnable within 10 days. The new law, the notice of petition shall be returnable before the clerk and shall be made returnable within 10 days. So what does this mean? The tenant, the time that a tenant has to respond to a notice of any petition has been increased from 5 days to 10 days. Again, more time. It further delays the eviction proceedings. 14, number 14 on page 27. Delivery of warrant response time has now been extended. The officer to whom the warrant is directed and delivered shall give at least 14 days notice in writing and in a manner prescribed in this article for the service of a notice of the petition to the person or persons to be evicted, and shall execute the warrant on a business day, so it's on a business day, between the hours of sunrise and sunset. What does it mean? The officer delivering a warrant during an eviction proceeding must now provide a 14-day notice to the tenant, which has been increased from just 3 days. Well, been increased from 72 hours. So again, the officer delivering a warrant during an eviction proceeding must now provide a 14-day notice to the tenant, which has been increased from 72 hours. The warrant must also now be served on a business day. Another change. This will delay evictions even further. Between the certified letter for the late rent after 5 days, followed by a 14-day pay or quit notice, followed by 10 days to respond, followed by another 14 days from a sheriff's notice, not to mention weekends and holidays, I don't see how it would be possible to evict a tenant in less than 60 days, and 90 would be unlikely. Oh, it would not be. So up to 90 days would not be unlikely. So for many accidental landlords holding mortgages on a single family home, as is common in some parts of the state, especially with military and the military, it would be possible for foreclosure proceedings to be held due to the landlord's inability to pay the mortgage on their rental before the tenant could be legally evicted. So it's mind-blowing. I know it's information overload. We're almost done. Almost done. Page 15. Oh, and just so you know, you don't need to know all these time frames. New York will not test you on all these time frames. But again, you should know that these time frames exist. So as a practitioner of real estate, you're aware of it. You don't want to be, I don't want you to be a mediocre agent. I really want you to be a superstar out there. So evictions can be delayed up to 12 months. New law, in a proceeding to recover the possession of premises, The court on the application occupant may stay the issuance of a warrant and may also stay any execution to collect the cost of the proceeding for a period of not more than a year. If it appears that the premises are used for dwelling purposes, that the application is made in good faith, and the application or the applicant cannot within the neighborhood secure suitable premises similar to those occupied. Oh my God, do you hear this? Let me just repeat that again. If the applicant cannot within the neighborhood secure suitable premises similar to those occupied by the applicant, and that applicant has made due and reasonable efforts to secure such other premises, or by other facts, would on occasion find an extreme, if they have like an extreme hardship, if an extreme hardship can be proven on behalf of the applicant or the applicant's family even, not just the applicant, but because remember, when people rent your property, they also have the right to bring in another adult and children, your children and their children, like, you know, they're probably didn't even know about all that, but that's all true. In determining whether refusal to grant a stay would occasion extreme hardship, the court shall consider serious ill health, significant exacerbation of an ongoing condition, a child's enrollment in a local school. So the school year just started and it might not be appropriate to have an eviction. Okay? Like, wow, that's considered an extreme hardship. The court shall consider any substantial hardship to stay, the stay may impose on the landlord in determining whether to grant or stay the setting length. It's mind-blowing. Number 16, next. No deposit or advance shall exceed the amount of, this is big, and this I see being on the state exam. This is really big. I'm sorry. No deposit or advance shall exceed the amount of 1 month's rent under such contract. Security deposits are now limited to a maximum of 1 month's rent, and landlords are no longer allowed to require last month rent up front. It's so mind-boggling. The changes are so mind-boggling, I can't begin to tell you. Number 17, tenant may require landlord to conduct multiple move-in or move-out inspections. After initial lease signing, but before the tenant begins occupancy, the landlord shall offer the tenant the opportunity to inspect the premises with the landlord or the landlord's agent to determine the condition of the property. You should always do move-in and move-out inspections and have it documented and take pictures as well. If the tenant requests such inspection, the party shall execute a written agreement before the tenant begins occupancy of the unit, attesting to the condition of the property and specifically noting any existing defects or damages. So that's all good. So what does this mean? Landlords must now offer tenants the opportunity for an in-person inspection with the landlord after signing the lease, but prior to move-in, and after notification of non-renewal, but before vacating. Tenant must have an opportunity to fix any issues before moving out. This is usually not an issue. I don't have a problem with that. It's good practice as a property manager or owner is to do move-in and move-out procedures. Okay. Last page, page 30, and we're done. Number 18, deposits must be returned within 14 days. This is a big deal, folks. Within 14 days after the tenant has vacated the premises, the landlord shall provide the tenant with an itemized statement indicating the basis for the rent, again, indicating the basis for the amount of the deposit retained, if any, and shall return any remaining portion of the deposit to the tenant. If the landlord fails to provide the tenant with the statement and deposit within 14 days, the landlord shall forfeit any right to retain any part of that deposit. Sometimes you don't know the cost of repairs in that short period of time. If you can't get people out to give you estimates, you don't know how much to keep. It just can you see where this just goes and like this just gets really ugly quick. And then if you don't get them the money within the 14 days, you lose all rights to it. So it's just, and then you go to court and then you try to go after people who don't have assets. It's just horrible. So in the past, the security deposit had to be returned within a reasonable period of time. They never defined what was reasonable. following a tenant that vacates. Now the security deposit and disposition form must be returned to the tenant within 14 days. So I'll let you read the balance of that on your own. I think you know where it's going, but this is all the new stuff that happened in July of 2019. And thank you for your participation this evening. It was great. We got a lot done. I know it's super late, but rest for a few days and read your material. And we'll be back next week, Tuesday, for more fun and shenanigans. Have a great night, folks. Take care.